Hey gang, Stephen Marshall, KYLandlordlaw.com, back at you with another update and some more thoughts on this source of income stuff. So today really is the day. This is November 14th, 2023. And this evening at 6 o'clock, the LFUCG Social Services and Public Safety Committee will meet, and they are going to hear public comment on the proposed ordinance that would require housing providers to accept all forms of lawful income, including two very problematic sources, and those are the Section 8 vouchers and income from other individuals. Now, I want to comment on both of those things. I've said most of what needs to be said about this issue. But in case I'm not able to speak tonight at the meeting, I want to comment on a couple of points, give some last minute thoughts. My daughter has a basketball event at 7 o'clock, so I'm not going to be able to stay at the meeting very long. I doubt that I'll get to speak, although I'm going to try. So what I would ask of the ladies and gentlemen who are on this committee and then later who are on the council is to consider deeply why so many housing providers are not willing to accept Section 8 vouchers. There are many that want you to believe that it's a racial thing or that it's a socioeconomic thing, and I simply don't believe that. And I would submit to you that it's because the Section 8 program does not work for housing providers by and large. The Section 8 program is not new. Okay, we're not hypothesizing about some theoretical new program. We're talking about a program with a long history and with which housing providers are very familiar. Okay, we don't have to speculate about how it's going to work. It is a known quantity. And so here's the fact. Here's what's proven. If the Section 8 program was a winner for housing providers, they'd be flocking to it. Okay, there'd be no need for these monetary incentives that have been offered to those who join the program and start accepting vouchers, and there certainly would be no need to mandate participation in the program. Programs that work well don't need to be mandated. People do them voluntarily. And as I noted last month, housing providers are at heart business people. And if the Section 8 program worked for them, if it was profitable for them, they'd be all about it. But it doesn't, and so they haven't been. Now, that does not mean that the people that run the Section 8 program are bad people or bad at their jobs. It certainly doesn't mean that. Like every organization, the folks that run the program, they have good employees and they have employees that are not so good. Sometimes those employees have to be let go because they don't do their jobs very well. And housing providers suffer when that's the case because their units sit empty or money that they were supposed to get doesn't get paid out. And so for me, the crux of this issue boils down to the vulnerability that housing providers will face in those instances in which they are required to participate in the Section 8 process. And make no mistake, under this ordinance, there are instances in which housing providers will be required to participate in the Section 8 process. That is simply a fact. Now, in those instances, housing providers will be at the mercy of the housing authority to coordinate and complete this Section 8 process in a timely manner. And that is simply a scary proposition because there is no doubt that the process does not get completed in a timely manner on many occasions. And that's at a time when the program operators have every incentive to make the program as attractive as possible to housing providers. So what would help? What would help is a guarantee. A guarantee that units are not going to sit empty when another applicant is ready, willing, and able to sign a lease and begin paying. A guarantee that housing providers can walk away from the program if they're faced with losing money. And there's a couple of ways that this could be structured. It could be a provision in the ordinance that allows housing providers to move on to a non-voucher holder who qualifies and is willing and able to sign a lease before the Section 8 process is completed. Okay? And by completed means that there's a lease signed and there's a firm date for payment to begin. Okay, that's option number one. Option number two would be a provision that allows the housing provider to move on from the voucher holder to a new applicant if a lease cannot be signed by the voucher holder within a certain number of days. Okay, either one of those would alleviate some of the concerns that we have and provide housing providers with some assurances that their units are going to consistently generate income and not sit empty. So those are just a couple of ways to alleviate these concerns, and I certainly hope that the committee and later the council are willing to consider them. Because here's the deal, if the Section 8 program is as smooth and expedited as it is being characterized as being, those deadlines should rarely come into play. And then the final thing I want to comment on is the portion of the proposed ordinance that would require housing providers to accept income from quote unquote other individuals. Okay, that gets problematic for housing providers when these other individuals who are providing the income are from outside the state of Kentucky. Now, if they're from Kentucky, it's not a major deal. They can be signed to a lease or a guarantee agreement, and it holds them responsible legally just like the tenant. But if they're from outside the state, housing providers are going to have a very, very difficult time collecting from them. Any judgment that was received against them in the state of Kentucky would then have to be domesticated in the state where that person lives, meaning that the housing provider is going to have to hire an attorney in that other state to domesticate the judgment and begin some type of collection action in that state. Even though you can sue within Kentucky and get your judgment, your Kentucky judgment's no good against the person who lives outside the state. So that additional step would create some additional expense for housing providers, and it makes it problematic. So it seems like there needs to be some type of provision added there that exempts housing providers from being required to accept income from individuals or entities that are outside the state of Kentucky. Okay, so those are a couple of things the committee and or the council could do to ease the concerns and vulnerabilities of housing providers. And I sincerely hope that those concerns will be considered and they'll be addressed. So that's my story. I hope you'll show up this evening at 6 o'clock at 200 East Main Street to tell your story. All right, that's it for today. I'm at smarshall@sslaw.com if you need me. Hope you have a great week.